Now. Okay, hello everyone. Welcome to the Hodlcast. Today we have special guest attorney Greg Karch. He's actually the managing attorney at my firm, DLT Law Group, and very excited to talk about the Telegram action. So thanks for tuning in. And Greg, can you maybe give a little bit of your background and how you got involved with the cryptocurrency space?
Sure. Thanks for having me on, Sasha. It's been something we've planned multiple times and just now finally getting ourselves to actually connect and do one of these podcasts. So that's good. I've been interested in the Bitcoin and crypto space since 2013. I started studying it in law school. Worked on a paper for a seminar course in 2013, published it in 2014. Then once I passed the bar, started practicing almost exclusively from the beginning in crypto and blockchain and representing different companies in the space as a business lawyer. Prior to that, I was a corporate paralegal, so I had a lot of background in business transactions. So I started to do that, and obviously in 2017, 2018, securities laws was sort of the forefront of everything that we've been doing in crypto. That sort of takes center stage, and so that's a big part of what I've been focusing on for the last several years. And now we're getting more and more interesting cases that come out, like the one we'll talk about today.
Yeah, we finally got some quite a bit of precedents to look at now compared to when we first started at all this.
Yeah, we're getting into some nuance and some more of trying to get into some of the issues that will help. And the SEC guidance that came out in April was very, very helpful, I think, in helping people to sort of understand at least what to be thinking about. And now we're getting some cases that are trying to apply those guidelines. Yeah. Cases, but more like complaints and we'll call them disputes between the SEC and token issuers.
Yeah. So what happened? Can you give us kind of an overview of what happened recently with Telegram?
Yeah, well, Telegram was ready to issue their Gram token, and they were going to do that here at the end of October. And they had been in talks with the SEC. They've been negotiating things, and I don't have inside information on any of those things, but I just sort of have followed it and understand sort of how it's progressed. And so they were moving along, talking about it, and then the deadline was coming up, and Telegram had sort of put together that deadline for themselves, that they had told investors that they would issue the tokens at the end of October and sort of put themselves in a position where they had to issue these tokens. But the SEC wasn't comfortable with what they were doing just yet, and thought that they were potentially at risk of issuing securities. Not at risk, they thought that they were going to be issuing unregistered securities, particularly as the October deadline came and they started to issue these tokens to existing investors. And so the SEC filed a complaint to stop basically the Telegram sale. And the judge and the parties sort of agreed that they would in fact delay it, and so they pushed back the hearing that they'll have into April. And so they're sort of on hold in a way, and so they're presumably continuing to work on those issues between themselves, but Telegram has not issued the tokens. They're sort of hanging on and waiting, to sort of resolve this either in February or potentially before that. We'll see how it goes down.
Mm-hmm. One of the things that I found really interesting in the complaint was when it gave kind of the biography of the two brothers that started Telegram. I thought it was kind of like an advertisement for them in a way. I'm sure the SEC didn't mean it like that. But they said, Pavel, age 35, he was a Russian, and he's now a Nevis citizen and co-founder, 100% owner, CEO of Telegram. But in 2006, he founded a website called BK that was a social networking it was basically the Facebook of Russia. And then he's an outspoken libertarian, and he's published free market manifestos urging the Russian government to deregulate their economy. And then he had a big clash with Russia in 2014, and they kind of took over the platform, the VK platform. And then his brother is also a citizen and co-founder of Telegram. And it went on to say, all the different, like 500,000 new users of Telegram every day, and 300 million monthly users. And I use Telegram all the time. I know you're on Telegram too, and most of our clients that we've
Yeah.
encountered in crypto are on Telegram. So it's kind of interesting. This is the crypto messenger, and a lot of the actions we've seen from the SEC have been these companies that don't really have a product or often don't have anything meaningful going on. But here we have, a very clear use case. I don't know where the grams fit into using Telegram.
Right. Yeah.
But it's at
Well,
least like a valid company.
well, that's true. That's what's interesting about this, more so than some of the others, is you've got an existing platform, a messaging system, and they're introducing tokens into their platform, putting a blockchain ion together, or Ton, not ion, Ton,
Mm-hmm.
and they're trying to integrate a blockchain and tokens into their messaging platform, which makes a lot of sense. Where I think it becomes a question is how they've gone about selling, and this is where the SEC sort of isn't comfortable just yet with. They use SAFT agreements, which we're both very familiar with, and most people in the space are familiar with. And the SEC's never really come down on SAFs as being bad, other than they don't like safes, so they don't like SAFs because they think they're risky. But they have a place in the private placement world, and it doesn't seem as if the SEC is going to come down on the SAFT agreement itself. But where what it turns on is when they start to issue these tokens publicly, and at what point do they do that? And that's why timing becomes the issue, which I think is really the key to this thing, is when are you doing things, and that type of question. And and selling a lot of tokens with SAFT agreements to a few investors with a substantial number of tokens is sort of the crux of what they've done. And the SEC cites a lot of conversations and due diligence and stuff they did with investors, where the investors are having this expectation that they've got all of these tokens and they're going to distribute them relatively quickly right after this sort of issuance, and that they can start to issue those tokens in large amounts and basically unleash these tokens to the public. That's not typically how a private placement sort of operates. A lot of times in stock purchase agreements and those types of things, you see language in there where the investors sort of state that they're investing and they're buying these private securities for investment and not for resale and that type of thing. It's important to put those in there because otherwise the investors start to begin to look more and more like investment bankers, and that's sort of what I think might be getting the SEC's attention here, is that they see this more as a way to distribute the tokens without registering them, by having these large investors under SAFT agreements and then distributing those and allowing them, in essence, to distribute those tokens shortly after they go live with the tokens. That's part of the issue. And then the other part of the issue, which seems to be in the guidelines that the SEC put out, is how functional is the blockchain going to be when they were planning to release these tokens at the end of October. My understanding is that it's just barely developed, that they're just getting it developed in some capacity, but that there's a year or two of sort of progress in building that they plan to do for this blockchain. And that means they're going to be retaining central control, which then gets us to the other question, is the decentralization question. And all of these come into play when we start to apply the Howey test to the time at which you issue these tokens and whether or not they'll be considered securities. The SEC is taking the position that these are unregistered securities that would have been sold at the end of October. Telegram is taking the position, their lawyers filed a response, and they're taking the position that these aren't securities, that these are utility tokens, that these are going to be used within the network. So this case is super interesting for us, because now we're getting to where a SAFT agreement, private placement to raise funds to build the blockchain, and one side is saying the tokens won't be securities. That's what Telegram is telling us. And the SEC is saying, well, you still have central control. You're distributing these massively to the public without enough information, because the SEC mentioned that several times in their complaint, that there's not enough information for Main Street investors to buy these tokens, and that's why we have registration processes. And so those become really important issues and questions that are in here in a very interesting way that I think is going to help us if we get to a point where the court actually helps decide these. But even if we don't, I think we're going to get insight as to where the SEC is going to fall on these issues, on an actual case, not hypothetical or not sort of theoretical like in their guidelines. This is going to be a really interesting application of their guidelines to see, maybe try to get a little bit more of a sense of where those lines are. And right now, there's a lot of blurred lines.
Mm-hmm. And do you remember how much Telegram raised on their Reg D? I think it was in the billions. I think it was like 1.7 billion or something like that.
Yeah, it was a substantial amount of money, and that was one of the questions that was raised. I have the exact number here in front of me, but and this is in the guidelines, and this sort of becomes a question of how much did you need to raise to build a blockchain?
Exactly. It was like
if you raise a couple, if you do a SAFT agreement for a few million, and then those SAFT agreements convert to tokens once your blockchain is built, that's a little easier to argue. But when you raise $1 billion to build a blockchain, are you really
don't build it in time for your token raise?
Yeah, you still haven't built it fully. You're just getting started, and you're going to build it over the next year or two, and really. And is it substantially built? And does the blockchain have to be substantially built prior to it having substantial use and qualifying as a non-security token? So it's the timing of this is really sort of quirky, and they sort of put themselves in a corner. The investors have agreed to extend that time so they don't have to give back money and all those things. But because they raised that much money to build a blockchain, it becomes fairly clear that this is potentially, and this is the SEC's contention, I think, that you're really using this as a method to distribute your tokens to get around the need to register them, right? And so that gets us to, one of the things that we don't hear a lot about. They didn't necessarily put this in their complaint as well, but it seems to be sort of in this kind of mold here in this case is even when you do a private filing under Reg D, if you're doing it as a plan or a scheme, is the way the code reads, to avoid registration, then even if you comply with all of the absolute requirements to meet for the exemption, the exemption won't be available. And so that's in section 5 or rule 500F of Reg D. And I'll read it just real quick, just so your listeners can see that I'm not making this up. It says that Reg D is not available to any issuer for any transaction or chain of transactions that, although in technical compliance with Reg D, is part of a plan or scheme to evade the registration provisions of the Act. And so if the perception is that that's kind of, you sold 1 billion tokens to a small set of investors, and they're not going to hold those. They didn't do that to invest in Telegram or in Gram, but rather so they could quickly sell them. And it's really apparent if the facts of the complaint that the SEC put together are true. They were promised some substantial returns and the ability to sell those tokens as soon as they were able to. And so it's not a good situation, it doesn't seem, for Telegram. Although, they seem to be going towards making the argument that these aren't securities and that none of that applies. So we'll see.
Do you know, and maybe I should have done a bit more research before we did this podcast, but what were the, like, how Telegram works great right now with no blockchain. How were they going to use the tokens? Like, the only application I could logically conceive would be for the sticker sets. Like, right now Telegram has a really nice way to make stickers on there, and then you can know how many people used your stickers. I make the stickers for each podcast cover. They don't get used very much in chats, but they're there. And there could be some way to monetize that with tokens, that every time someone uses one of my stickers, I get a couple grams, and someone pays a couple grams to use the stickers. But other than that, I don't really see I don't understand how they're planning on using a blockchain on the chat function.
I think that you're not alone with that, right? So there is sort of this open question of what is the utility, what is the function. You can integrate blockchain and the Gram token within a chat platform to allow people to make payments between themselves. Of course, that would be a fundamental utility, likely, like any other cryptocurrency, that you could just operate it in that way. But I think their idea is to build more, but I don't know that it's entirely clear what that is. I think that's sort of, it's part of the problem, but not necessarily the problem, because it's just too soon. And I think timing becomes the bigger question, because when you start to sell the tokens, that's when you have to do your Howey analysis, right? Is when are you going to issue the tokens? We know that SAFT agreements are investment contracts. Nobody disputes that. The question is, at what point do those SAFT agreements terminate, convert to tokens, and what is that token at that time? Are they oranges, or are they still equities, or some sort of representation of an equity that would meet the Howey test, which, as we know, centralized, for-profit, investment of money, common enterprise, those basic fundamentals. And so that's the analysis that you do at that point. And so is it going to be, I mean, obviously this is an attempt to get it quickly decentralized, but there's a set of investors that are selling public tokens for a profit, that sort of transition is messy. It's not a clear transition and a clean transition from SAFT agreement to tokens. And that's really the crux of the problem, I think, that the SEC identified, and that Telegram and their lawyers are going to have to try to figure out. Maybe they can delay, now that they've got the approval of investors to delay the launch of the tokens, maybe they can delay it sufficiently to where they can convince the SEC that they've got enough of a utility on the platform that now it's not a security token. I think that's where they need to be having the conversation, but Telegram's lawyers are still saying we're just not a security right now.
Probably.
Already.
I think what I'm understanding is, if they had have used the 1.7 billion that they raised, created a blockchain, deployed it, got it listed on exchanges, had a good valid use case for it, then did this, it still would have been the first, the SEC might have still stepped in, because we haven't really seen a lot of companies get away with a lot have gotten away with it, but the SEC hasn't examined it that closely, or decided if that's in their view okay. But like with Ethereum, when they had that sufficiently decentralized, Director Hinman gave that famous speech. When was that, like a year and a half ago or now?
About a year and a half ago.
Mm-hmm. There was a lot of controversial views around that, but eventually, the CFTC just determined that they're commodities, and I think that's what Telegram is going for here. But they're not many people say Ethereum's not sufficiently decentralized, but Telegram's not nearly at the level of Ethereum either.
And Ethereum is a really interesting case, because that really highlights sort of the question of the timing, right? Because if Ethereum was right now where Telegram is, and had pre-sold tokens, and the pre-sales are the question. So they pre-sold Ether back in 2014, I think it was. Mm-hmm. And it was a year before they issued them. and then they issued them, and they were able to utilize them in some fashion. They actually sold the tokens where people had the right to those tokens, and that was, but today's, that would probably have been a security in ICO, and they probably would have had some things to get overcome there.
Mm-hmm.
But like you said, we're 4 years down the road now, or we were at the time of Hinman, sort of where there was a focus placed on ETH and whether or not that was a security. And it's become so decentralized at this point that they recognize that it would be so difficult to unwind that and go back with all the trading and stuff that occurred and so on, that Ether sort of got a pass, a sort of a free pass. I don't think that you can rely on that going forward, that you're going to get that treatment, but it's a similar kind of treatment that it appears the Telegram is sort of searching for, but they're not even at that point yet where they can, at least it doesn't appear. We don't know where that line of decentralization is, and how we define decentralization is still very much a question. Mm-hmm. And so we don't know, how that's going to play out.
And I think you kind of touched on this earlier, but the guidance that the SEC gave us last April, they really talked about, and when they issued that no action letter for the turnkey jet solution, or turnkey jet, I forget the third word of it, but
Jetcoin, I don't know if it was called Jetcoin, but yeah, I know.
Yeah. They said a big deal was that the cost of the utility token is very similar to the cost of buying a ticket to go to the jet, or the same thing could be looked at for a movie pass. Like, you buy a token that will get you into a movie or a play, and that token should cost what the play would cost, and it should only have the amount of supply of people that could use it, not for investment speculation, but to go actually ride the jet or go see a movie. And I think that's a big difference compared to what a lot of the companies are actually doing, is issuing, billions of tokens to be sold, not for the actual utility that's being listed. And that's kind of what the SEC was zoning in on. But here we don't even have enough information on what the utility was going to be for it. But if
we assume that there's going to be a utility, and you can see potential for, even just as a payment system within the messaging app, that's probably sufficient enough to at least be, maybe not a utility, but at least you get into the currency sort of realm, and you're a commodity, and you're no longer a security, which is sort of the key to getting outside the SEC's jurisdiction, is you're just not a security. There's probably a path to that, and they can probably do enough to get to that point. The question is, are they at that point? And I think that becomes, like I said before, the timing is where it gets a little bit quirky. So, and what's interesting with this too is this isn't just a clean, we have a bunch of SAFT agreements, and at some point we're going to get tokens when those SAFT agreements end. There was a group in Asia that sold future interest in the token on Liquid, and so now you're starting to create a public market, even though it's not for the token itself. You've got a market that was created for your token. Now, they didn't have a hand in that necessarily, but that's not a good thing. When there should be restrictions on the resale of those tokens, and under the SAFT agreement, and that's sort of on them. But if you allow for, and I actually think there was, so I don't think that the investors were actually complying with what their agreement said. A different question, I suppose. But it's important because now there is actually a sort of futures market for these tokens, and there is some trading that's occurring. And I think that sort of got the attention of the SEC as well, because we don't have a very good handle on the sale of these tokens. And we're about to dump billions of tokens into the open market to the public, and they got very uncomfortable with that deadline that was approaching, and so they shut it down and put the brakes on, and want to make sure that people aren't going to, that the public is going to understand at least and get the information they need, and so I think that's a unique sort of, again, we look at the facts and circumstances of all of these cases when we analyze them. And this is a very different set of facts and circumstances than what we've seen in some other cases that have come down the line, like Kick and some of those other ones. And so it gets confusing for people because they think that the SEC is treating different companies differently and so on. But really, the facts and circumstances of each one have to be distinguished and applied to the Howey test and the guideline of the SEC in order to really dig into the nuance, because each one has this different set of facts and circumstances that are important.
Mm-hmm. And in Telegram's response, like when I think they got the emergency action or whatever on October 11th, they responded on October 17th, and they were saying it was kind of a scathing response against the SEC, saying, we've been in open conversation with the SEC for 18 months. We've provided and sought, they went and met with the SEC 3 times. They answered what they called hundreds of questions, and then got this emergency action that they said was, the SEC's own making, that it's an emergency. And, maybe the SEC should have taken, if they had an issue with this, there was 18 months of time to address it. It was known that this October 31st, distribution of the tokens was going to come. And I heard that from a few other lawyers that have worked with companies that ended up on the other side of these SEC complaints, that it's often a shock when everything's really nice with the SEC, nice communication, and then boom, you get this, kind of out of left field suit. So that's
it's a difficult situation because the SEC comes out and they says, all of you fintech companies, all you crypto blockchain companies, come work with us. And they built the sandbox or the lab, I forget what they call it exactly, but and they encourage people to come in and talk about your projects, go through their projects. And so there are some people doing that, and it's not as definitive, and it's not necessarily the answer every time. So it's a challenge. It's interesting because they want, at the same time, the SEC is open to concepts and ideas, and you can see it in their guidelines that they're getting some of this, and the SEC certainly is far further along than they were in 2017 in understanding what's going on here and finding solutions. But their mandate is to protect public investors, and they're going to be very cautious with that. That's why we don't see ETFs approved and things like that, because the markets aren't very well established and regulated, and that's continues to be sort of a problem is until we can be comfortable with the markets, public investors are going to be sort of the main concern of the SEC. Even if you go in and talk to them about your project and everything seems fine, if they get nervous about public investors and mainstream investors, they're not going to give in. Mm-hmm. And they'll change their tune pretty quickly. So I think what's interesting is the way Telegram sort of put this deadline in, that they were sort of up against it, even though their development schedule seemed, at least it appeared, I hope it was a little bit behind, because issuing the tokens at this point seems a little premature in the context of the SEC's guidelines and what I've come to understand the SEC is looking for. It seemed like they were jumping the gun a little bit. And so the pre-sales and the trading of the future interest in the tokens that would be issued, all of those things start to sort of rise to this level of conditioning the market for your sale and things like that. Those are also bad things to do in securities law.
Yeah, well, I didn't know when you said they were sold on liquid and with those, was it whatever the Asian group? I didn't know that
name
had
of the Asian
happened.
group, but there was the group out, and they weren't selling the tokens themselves, just selling the interest in them. So these investors had jumped the gun and started selling tokens before they were issued because they could. and so it's interesting, and putting tokens onto exchanges sort of, that still continues to be sort of this sort of unanswered question that if you're issuing a utility token, do you really need to list them on an exchange? Why do they need to be traded? Can you not just open a token store and sell your tokens and advertise and sell them as useful tokens and allow people to just purchase them? Or
Greg, that would
what
take
is
out
that?
all the fun of
I know.
trading tokens.
I know. The trading of tokens is something that it's sort of this blurring line between securities and non-securities. It's like,
Yeah. Big
you,
fun.
you can trade baseball cards, but we don't have exchanges to trade baseball cards. And we really don't need them. You can just buy and sell them. So maybe what we need is a token Amazon, somebody who just buys and sells, but it's not necessarily an exchange where people are trading and charting the price and those types of things. Who knows? I mean, where this is evolving, and we'll see where these things go. But a token, a token is just a token until you start to put facts and circumstances to it, and then we have to navigate through which regulatory agency is going to be overseeing what you're doing.
The way I see it these days too is the money transmission rules that that apply to a utility token. So it's like you either have the SEC to contend with or FinCEN. So if you're a utility,
and that seems to be this isn't really the purpose of this call or this podcast necessarily, but the money transmission laws are they're a little bit challenging in the sense that if it's a utility token, is it really money should it really be money transmission? And I think there's some work to be done, I think, on that aspect of that issue with
comparison to baseball cards. We certainly don't have to record everyone's name and address and get a photo of their driver's license to trade a baseball card on eBay. But
and art, antique art or really, really valuable and expensive art gets traded all the time. So we don't have those mechanisms of KYC, AML, money transmission, all those questions so if we're going to treat tokens as property,
for tax, let's give them the other benefits of being property in terms of not requiring the money transmission. But it's weird because they're not, they're their own thing, and they're not the same as a physical item, but anyway, it's just a weird it's been fun watching it all unfold. And
well, and part of the problem, part of the issue is we haven't yet gotten to that point yet where we can point to, other than the jet coin you referred to and maybe a handful of others, where we can really point to a token that is issued at a time where it has a full functioning purpose. I don't think we've seen a fully engaged utility token just yet, but they're coming.
Yeah.
And then we'll start to have to. That will give regulators a chance to look at something that is not a security, and maybe even not a currency, and look at it and say, all right, money transmission doesn't seem to apply here. KYC, AML, this is a product. We don't do KYC, AML on software sales. Or on ticket sales when we sell tickets to sporting events and such. All of those things that could be digitized and run on blockchain. When those things start to come out, then we have to question, does transacting for this token that is a utility token trigger money transmission laws, KYC, AML, and all that stuff? But those are questions that will be coming down the road.
Interesting times. Well, Greg, thank you for this. Has been, I think, very, very informative on the Telegram situation. So I really appreciate your taking the time out today to go through it. And where can people find you?
Well, we can, our webpage, both of us, right? We work together at DLT Law Group. You can reach us at www.dltlawgroup.com. And that's probably all of our contact information's there. Email, and you can email me also at greg@dltlawgroup.com.
Awesome, and I'll put that in the the description under the link for the video and audio files. All right. Well, thank you very much. And I guess we'll keep watching. When's the next hearings? They got delayed till April.
They'll be in April. The hearing will be in April, but we'll see if they make some progress in some sort of settlement prior to that. I would hope that I would guess that's what they're doing. Is typically that's the way these have been ending, and it's a sort of a double-edged sword, right? We don't get a lot of clarity from those settlements, but we get at least some understanding of where the SEC is, but that may or may not be where the courts would fall, and so it'll be interesting until we start getting these to progress to the court level and see what the courts start to say. I think it's going to be a long process of sorting through a lot of these issues.
Yeah, I think that the legal fees on fighting the SEC are pretty high, but Telegram is sitting on 1.7 billion, so maybe they're the
Yeah.
ones that'll take us there.
Yeah,
Everyone
and
else
maybe
just
that's
get
their
out of it.
justification for raising those funds, is not to build the blockchain, but defend their ability to build a blockchain and pay their lawyers to fight it.
Yeah, yeah. Well, I hope they do. I hope it does go through the courts. I'd love to see, see how
Yeah,
it
well,
falls, because I
like
think
I said before, this is one of the very first ones where we're really getting a really interesting look at sort of that nuanced question that is in the guidelines that the SEC put out of where is the timing, what happens to a SAFT agreement, and at what point are you sufficiently decentralized? All of these questions could be answered by this case, but we'll see if they get answered.
Yeah.
So
All
we
right.
will be
Well,
watching.
yeah. Stay tuned. All
Yes.
right. Thanks, Greg. I'm just going to
All
end
right.
the
You're welcome.
recording here.